Debbie, can you call roll, please?
Matt Burr.
Here.
Matt Edstrom.
Here.
Kendra Baldwin. Here. Teresa Moreland. Here.
Tonight we have a workshop discussing KOMA and KORA with City Attorney Andrew Kovar.
Thank you, Madam Mayor. Mayor Council members. Sorry. Thanks for having me again. Of course, I'm here every meeting, but you have all seen in one form or another probably most of this presentation before, but of course it is, in my view, I think it's always a good reminder every few years, especially after elections, to have a little bit of a review of what I call Cities 101. I want this to be kind of an open dialogue. Please don't hesitate to ask me questions as we go through this. I'm used to that. That's how most of these things go. And so I have this presentation, but it can certainly be free form. We can focus on what's of most interest to you if there's something that grabs your attention. So starting off, just in general in Kansas, so you kind of know where Kechi falls, there are 3 different types of cities. There are cities of the first class, cities of the second class, and cities of the third class. So there are a lot of differences between these kinds of cities. The reason why I've got the KSA chapter set out there is because in my world, each one of those classes of cities is governed by a separate section of the Kansas statutes. Chapter 12 applies to all cities, but then first class cities are under Chapter 13, second under 14, and third class under 15. Primarily the way that you determine what class of city you are is by population. It was determined when the city was incorporated. So Kechi is a city of third class. So we fall under Chapter 15 when I have to go look up some statute that applies to the city of Kechi. And that means that when Kechi was incorporated, it had fewer than 2,000 in its population. Now it has more than 2,000 in its population now. And what happens when you cross that threshold is the city has to make a decision. It either converts to a city of the second class, or what Kechi did is it passes a resolution that says, notwithstanding the fact that we have more than 2,000 people, we want to stay a city of the third class. And so there is a resolution on file, and that happened several years ago, that the city passed to stay a city of the third class. When you get to 5,000, you won't have that choice anymore, and you'll have to convert to a city of the second class. Lots of differences between the classes of cities, which we don't have to focus on here, but I like to preface that, because you'll hear that as you work with other city council members, commissioners in various places, and they may do things differently, and some of that may be derived from the type of city that they are. Within those classes, no matter what class you are, there are a couple, there are really 2 main forms of governance with a couple of different flavors to that. The first is mayor-council, which is what Kechi is. It is composed of, I like to analogize it to the federal government, although it's not exactly the same, but it's a useful way to think about it. Mayor-council form of government means we have a city council. That's generally sometimes called the governing body. It's elected by wards unless we've changed that, which we have here. The city council takes care of the legislative function, so the passage of laws, the adoption of resolutions, which are like policies, all those things that you do every time you come to a meeting, those are the legislative functions and determination of the city council to pass the laws of the city. The mayor then is kind of like the president, the executive officer, who is charged with the executive functions to execute those laws that are passed by the council. Now, obviously, that's not an exact analogy because the mayor presides over the meetings of the council, which is different from the president, and is elected by the city at large, which is distinguished from commission here in a moment. And then you have either a manager or an administrator of the city that does the administrative functions. That's an office that is created by the council itself. It's not necessarily set out in state law. It's created by the council itself. The other form of government, which you may come across as you work with other basically have the same kind of three functions. The commission serves as legislative, the mayor serves as quasi-executive, and then you have a manager or administrator in city commission cities as well. One of the largest differences between these two forms of government, however, is in a commission form of government, the mayor is not elected by the people at large. So the elections are for the commissioners on the governing body, and then after, actually every year, the commissioners then vote between them which of the commissioners will serve as the mayor for whatever that period may be that the mayor serves in that city. And so that's one of the main differences when you talk about a mayor in a council city and a commission city. That actually makes some differences, which we may cover here moving forward, but that is one thing you may hear about as you
Andrew,
yes,
I'm
please.
trying to remember, I'm trying to think of a city that's an example of that. Is Goddard a commission? I think they're governed that way.
Yeah.
Newton
Yeah.
is as well.
Yeah.
Newton,
Very
Goddard.
common. Parsons is. I was just up there a few weeks
Parsons.
ago. Yeah. There are many of them.
What's the benefit for going commission based instead of?
I wouldn't say that there's a benefit. It's just sort of historically how that's been determined. Most commission cities, you have to have an election to go from council to commission form. Most of that happened over 100 years ago in the places that are commissioned, and so why the people at that point in time decided that they preferred that form of government, who knows?
What's the difference typically between an administrator and a manager?
So there is a whole set of statutes that it's sort of the same way as determining whether you're a council or a commission form of government. There's a set of statutes that says the people can vote to have a city manager rather than a city administrator. And it sets out a whole sort of restructures a lot of the authorities that reside in the council and the mayor that go under city manager. And the most obvious one is all of the officers in the city manager form of government are chosen by the city manager. So, for example, Wichita has a city manager rather than a city administrator. City manager determines who the city attorney of the city of Wichita is, as an example. Some of the other things, well, we'll get to that. One of the important things that I want to cover is meetings. This is the Open Meetings Act, which you certainly have heard about. And it doesn't matter what form of government you have. The Open Meetings Act applies to all governing bodies. Open Meetings Act applies to, frankly, all bodies within the city itself, whether that's a library board, or a park board, or planning commission. KOMA says there are 3 types of meetings. There's a regular meeting. What is a regular meeting? Well, we're kind of in a hybrid right now, but regular meetings are the normal meetings that you have every 2 weeks or every second and fourth Thursday of the month. They are scheduled, or they should be scheduled by an ordinance. So your code says when your regular meetings will be. There's a reason why it's that way. You have to have at least 1 meeting per month. So, for example, we frequently do not have a second meeting in November and December because of the holidays, and that's okay. But if someone were to ask me, hey, in November, there's some reason why we don't have enough on the agenda, we want to cancel the first one too, I would say you can't do that. You got to have at least 1 a month, that's what the law says. If you wanted to cancel the second meeting or the first meeting in any of the other months, you could do that so long as you still have a meeting that month. Regular meetings have open agendas. So the city puts together the agenda every month or every meeting, and we go through the exercise of walking through that and having an approval of the agenda and discussing what's going to be on it, and all of that is right and orderly to be sure that we are proceeding the way we should. But even though we have that all laid out, any council member or the mayor can really bring up any topic at a regular meeting that they want to discuss. Even if they haven't, it's not on the agenda, even if you've, quote, approved the agenda and later on you want to say, I want to talk about this thing, that's just fine. That's what the regular meeting is for, is to cover those things. You have a question, Doug?
No, I'm not thinking.
Okay, okay.
I'll raise my hand.
Yeah. And just like every regular meet or any kind of meeting, you've got to have a quorum in order for that meeting to be valid for, and what does it mean to have a valid meeting? For the council to take any kind of action, legal action, you've got to have a quorum. A quorum is a majority of the members elect of the council. And so you got 5 members of the council, that means you'd have to have at least 3 council members present in order to take any kind of actions. That's how many members you would have a quorum to hold the meeting. The second type of meeting is a special meeting. So really any meeting that's not on the regular schedule is a special meeting. You can call a special meeting really at any time. The differences between special and regular meetings are, well, first, it's called by the mayor on the request of 3 members of the governing body. You guys just did this, so it should be a familiar process, right? The notice has to say the time, place, and the object purpose of the meeting. That notice should go to anyone who has put their name on the list with the city that they want to receive notices of special meetings. In most cases, the city clerk keeps a copy of that list. Most cases, that's the newspaper and any citizens who want to have notice of those things. You'll hear about this from time to time. It is permissible for the city to purge that list once a year in order to sort of keep it clean. Some cities will tell me, we've had the same list for 50 years, and clearly there's a whole bunch of people on there that haven't been to a meeting in a long time. It is permissible to purge the list, but in order to purge the list, you have to provide notice to everyone on the list that you are purging it, so they have the opportunity to ask to be back on it and to remain on the list. So, yeah, if you have a long list that's 50 years old, it's probably worth going through that exercise. If you don't, and most of the people, it's not an unwieldy list, I usually don't recommend you bother with that, because those people still want to receive those notices.
I did have a question.
Yeah.
So is there a certain, do you have to have a 24-hour notice or 48-hour notice?
There's no hard and fast rule.
Okay.
The law is reasonable notice. Reasonable notice.
Okay.
So I always think about it like this. If there's a water main break, and I don't know what the council would need to do about that, but if there's some kind of an emergency and you just really need to get together and make some decision right away, then you have to be able to do that. And so the best thing you can do is, maybe call the newspaper and do the best that you can to provide notice that you're going to have a meeting. But if it's an emergency, you got to do it. As a matter of fact, emergency is a clear exemption. But if there's a decision that has to be made in the next 24 hours, send out the notices and do the best you can. If, however, the topic to be discussed is really not going to be any different today, tomorrow, or 3 days from now, then, give 48, give 72 hours notice that you're going to do that, to give people a reasonable opportunity to come and attend if they want to. It's kind of a common sense test, I would say. One of the big differences with the special meeting is it does have a closed agenda. So the only business that you can do at a special meeting is what you've put in the notice that you are going to do. And if you think about that, this is intended to give the public notice of what the topic is. So the public knows that there's a regular meeting every second and fourth Thursday of the month, and they know if they come to that meeting, they will hear anything that needs to be done by the council. If you're going to hold a special meeting, you need to tell the public what it is you're gonna be discussing so they can determine whether they will attend or not. And it would be really unfair to them to notice that we're gonna talk about X, and then get there, and maybe you do talk about X, but then you make some decision on Y, and nobody had any notice that that was going to be the topic of discussion. And so it is a closed agenda for a special meeting. You gotta stick to what's in your notice of that meeting.
And this would apply not just to this body, but to the park board and the planning commission as well.
Yes, it does.
Okay.
Yes, it does.
Thank you for that.
The
So
third,
All committees.
all committees, yeah.
Well, not like the fair committee, because the fair committee is not a governing
It's a civic.
agency.
Correct. Yeah. I mean, you gotta make a distinction.
Okay, well, that's why I just wanted to make.
Yeah, this is city bodies, absolutely. If it's a citizen board of some kind, not technically formed or organized by the city, this doesn't apply. The test is actually has to do with whether you are formed by the city and or supported by public funds.
Okay, so like the park board is an advisory board. And the fair committee is a volunteer
It's a
board?
civic.
It's a nonprofit, not affiliated with the city.
Right.
Not appointed
Right.
by the mayor.
Right.
Okay,
Yeah.
that's what I needed.
So like we used to have an economic development committee or board,
Yeah.
and that would be a city board.
That would be a city.
Correct,
Right.
that's right. Third type of meeting is an illegal meeting. And then, and again, we just sort of went through this at the last meeting. There is a distinction between adjourned and recessed meetings. An adjourned meeting means it's over. A recessed meeting means we are pausing until we pick this meeting up again at a future time. What we did to have this workshop was kind of a recognized hybrid. It's been somewhat blessed by the Attorney General. As a hybrid between a regular and a special meeting, what we did was we recessed our regular meeting at the last meeting in order to come back together today, which the rules surrounding that are the agenda can still be open because this is still considered a part of the previous regular meeting.
Okay.
However, all the other notice requirements apply as to a special meeting. And the threshold for that is 24 hours. If you recess more than 24 hours, the AG has said you should give notice as if it were a special meeting. But the agenda can stay open.
Okay, so we just had two, in between last meeting and this meeting, two special called meetings. And in those meetings, we adjourned them because it was specific to that agenda item. We didn't recess.
Yeah.
Okay.
That's
Yeah,
right.
I'm just clarifications and just good.
Yeah,
Thank you.
good.
Holidays and rescheduling, this is just to point out that it's okay. There's a little bit of flexibility with regular meetings. If you need to move a regular meeting for holidays or to reschedule for some reason, that's fine. The best practice is to do that at a regular meeting so that the world is on notice that we have moved it to a different, to a different time. If you don't do that rescheduling at a meeting, then you run into it's probably becomes a special meeting, and then you got a closed agenda, and it gets a little bit tough to deal with.
So on the special meetings, and you said that it had to be 3 members of the governing body,
Yeah.
and there's a special form for that? What if it wasn't signed by 3 members? Is the mayor considered one of the governing body on that request?
It should be city council members.
Okay.
It should be city council members of the 3. Yeah.
So we didn't do it
We
correctly.
didn't do that.
Oh.
That's good to know.
Well,
We thought it was a,
We did mayor
We
and
thought
2
it was the mayor
council
and 2
members.
council.
so-
But, okay. Okay, now you get to stump the band. But everybody showed up at the meeting, right?
yes.
Okay. Then I think we've cleansed it from a legal perspective.
Okay, so
I just-
not all members of the council showed up at the special meeting.
But
But they
a
did.
quorum.
A quorum showed up.
Yeah, a
Okay.
quorum attended.
Okay,
So-
so we're,
So I have a question on that, because you said a special meeting is called by the mayor,
Yes.
so it's called
That's okay. We learn.
Okay.
Again,
Three
a quorum
council.
came to the meeting, so I think no harm, no foul. on
Yeah.
that
Yes.
one.
Yeah.
It was valid.
And there was people in the public that
Yeah.
came too, so, I mean,
And it was
people
noticed
people
up.
knew.
Yeah.
Yeah, I just wanted to make, I
Yeah,
just
no,
wanted,
that's great.
because of what had happened with that, I just wanted to
Yes.
make
Yeah.
I
clarification,
thought the
so
mayor
that
did,
moving
so
forward,
sorry.
we did it correctly.
Yeah,
Now we know.
absolutely. Good question. So then what is a meeting? I know we talked about the different types of meetings. But there is a definition of what a meeting is under the Open Meetings Act. That's any kind of gathering in which there's interactive communication. So I get this question a lot: can I attend by telephone? Can I attend by Zoom? The answer is yes, you can, as long as everyone involved can be heard and can understand everybody else. So if there's interactive communication, that constitutes a meeting. A majority of the membership of the body or agency subject to the act, we kind of talked about that if you have a quorum. And for the purposes of discussing business or affairs of the city. This is the body of the agency, but of the city. So, a couple of different scenarios that come up in this regard. If we have a regular meeting where 2 members of the council and the mayor are here, but we're missing 3 members of the council, we don't have a valid meeting, we can't take any action. Sometimes people will look at me and go, can we talk about something? I'm like, actually you can,
Oh.
because
Can-
it'd just
can
be
you
like you're
repeat
meeting in
what
the
you
parking
just-
lot.
Can you repeat what you just said? I
Sure.
lost that here somewhere.
We have 2 members of the council
Yeah.
and the mayor that come to the meeting, but we're missing 3 members of the council. We don't have a quorum.
Right,
It's not a meeting.
gotcha.
Can't take any official action. You could actually discuss city business because you don't have enough people to take an action.
That's what I wanted to make
Okay.
sure.
Um,
So for example,
yes,
if Joni, Teresa, and I see each other at Jumpstart, we can have a conversation about any city thing, but if a third council member showed up at Jumpstart, we could not.
exactly.
Gotcha.
That's exactly right.
Okay. Gotcha.
Now, if 3 council members all go to the summer barbecue in the park and do not discuss city business whatsoever, also just fine.
Which we
Right.
do with the movies and the Friday movies in the park.
Yep.
There's more of us there, yeah.
Mhm.
But we can't discuss city business.
Correct. Correct.
So I always understood it, I'm just clarifying that.
Yeah.
I have a question. I don't know if there's gonna be a part where we talk about violations or not, or meetings, like, I have some questions I wanna ask.
Go ahead.
Okay, so, prior to a council meeting, if there are more than 3 council members behind the staff door, that's actually considered a meeting.
If there are 3 council members,
In the back room where no one can see them.
if they're discussing city business, then I would agree with you. If
But we
they're-
don't know, but the public doesn't know, because if they watch council members coming out, there's no idea for the public what has been discussed behind closed doors.
That's true, but I suppose that's true of at any other
Okay.
time as well.
I
Like
get
and we
like
don't-
at Jumpstart, it's
Yeah.
the same
Yeah.
thing.
This is
Right,
what I'm just
yeah.
asking for clarification.
Absolutely, yeah.
So, because then sometimes too, like, the November 13th, 2025 meeting, there was a recess where the entire council went behind in another room, and the public was here, and nobody could see them or hear what was going on. Is that appropriate?
Well, it's not illegal
Okay,
unless there's some indication that there was city business being done.
okay.
Yeah.
So,
It's just that perception.
You are correct to point out there's a difference between legality and perception.
Correct.
I'm
And so that's
I'm
what
not
I'm just
disputing
like,
that
to
whatsoever.
like, if we're trying to build accountability, transparency with the public, then we also need to not just think about legality, but also perception. Because if everybody watches a whole council go behind closed doors, and it's not an executive session, it's like, the perception is like, what are they doing?
Sure.
Even if it was a recess for 10 minutes.
Right.
So, how would you best handle that situation if there is a recess that's being taken during a council meeting?
You know, I think that's a determination for the council and the
Okay.
mayor to make. I mean,
Okay.
like I said, unless somebody tells me there was city business being discussed, you know,
Right.
I'm not gonna say you can't go back there and get a bottle of water.
Okay.
But I understand exactly what you're saying.
Yeah.
I guess I'm saying, I think it's a policy question rather than a
Okay.
legal question. And there is definitely a place, I mean, we're talking about some of it, we can get through there, but there's definitely a place for keeping an eye out for perception
Right.
versus reality.
Correct.
That's absolutely true.
Absolutely. Thank you.
And I'll just say historically, being on the council for 6 years, we've been very conscientious of that. Before meetings, like somebody will come up and, let's say I'm talking to Todd and Kendra comes up, it's like, oh, we can't discuss anything because the third person just walked up.
And I will tell you that in my experience, not with Kechi in quite some time,
Yeah.
you guys have taken my advice well from what I
Yeah.
can tell, but it is inevitable when I'm at a different city council meeting, the meeting will end, and then 3 people might huddle somewhere, and I will walk over there and
Oh,
say, I hope you're
Yeah.
not talking about city business, I hope this is about dinner
No,
tonight.
yeah, and we've even
Yeah.
had that happen here, like when we're standing out here
Yeah.
talking.
And they don't even
With-
intentionally do it, it's
Yeah.
just
Right.
human nature.
Right.
Yeah.
We might be standing here talking with some constituents, and 2 of us may be talking to, Chris or something, and then a third person walk up and it's like, oh, now
Yes,
we got
that's exactly what you should do.
Yeah.
Mhm, mhm.
Yeah,
Some other places that, we talked about quorum. And we kind of implicitly mentioned the mayor doesn't really count
No.
in the quorum.
Correct.
Some other places that meetings could happen you might not think about is in this electronic world. And so email, I know we've talked about this before. The city administrator, for example, can send out an email to all the council members to disseminate some kind of information. You should not reply all to that email, because as soon as you do, you've created an interactive communication that constitutes a meeting.
Right.
So sometimes if I send out an all council email, which doesn't happen very often because I try to be careful about it, but if I do, I always try to put at the bottom, please don't reply all. You have a question, don't hesitate to reach out to me individually, but don't reply all.
Can I ask a question?
Yes.
So, I know that in some cases blind CC gets used. Is that acceptable, or is that a gray line? So it's like you're sending it to one person, but then everyone else is being blind CC'd.
No, I know what YNCC is.
They can't reply to all, but you're,
Oh,
So it prevents.
they can't reply to all.
well, yeah, that's okay. Yeah, so you can't
I just
reply all.
wanna,
That's how
I
it
just
sends
want a
it.
clear answer. Yes,
Yeah, I think that's fine.
okay, yes.
Other types of electronic communication and social media in particular, and we may get to a discussion of a new Supreme Court case. We get to the end of our presentation, but those are also ripe for accidental violations of this because they inherently involve interactive communications. And so Facebook, for example, is a classic one. That's the Supreme Court case that we'll talk about later. But you know, if you post something on the internet that is business related, and then a council member replies to it, okay, you're good.
But if
There's just only 2 of you, and I mean, if a council member posts it,
Right.
and another one responds, but then as soon as the third one hits, now you've got an
Yep.
open meetings violation. So, be careful about that kind of thing. And any of those kind of social media in particular, be very careful. Chain meetings, okay, so once you have this discussion with intelligent people about don't reply all, don't have meetings with more than 2 council members present, everyone eventually figures out, well, okay, so I can have a meeting with council member A, and then I can have a meeting with council member B, and then I can have a meeting with council member C, and then, okay. That's called a chain meeting. Now, there are times, for example, when it's okay for city administrator, it's okay for a city council member to have individual meetings with council members on business topics. That's okay. Where you create a chain meeting and draw the line is when you start discussing those other people's views in the subsequent meetings. Okay, kind of I'm trying to build, you think about it, I want to see what everybody knows, I want to build a consensus, I want to start counting votes, and so I have a meeting with council member A to get their view, and then I have a meeting with council member B to get their view, just fine. And then I go to council member C and I say, what do you think about this? Also okay. But then you say, A and B think this, now you've got a chain meeting, you
Yeah.
can't do that. That's a discussion that needs to be held in open session. And as we've all been assuming, the rule is, once you've got a meeting in any one of these forums, the law says it has to be in public. Unless it is a proper executive session. Executive session is the only exception where you can have an actual meeting that is not open to the public. The law has several pages of exemptions that allows you to meet for executive session. But in my experience, these are the three you will almost always use. 1, personnel matters, non-elected personnel. 2, attorney-client privilege. Or 3, preliminary discussion of acquisition of real estate. There is no blanket executive session exception for contract negotiations. I see cities do this all the time. We're going into executive session for contract negotiations. Now, that doesn't mean that a contract negotiation can't be part of an attorney-client privilege discussion. It absolutely can be. But if that's what you're going to discuss, it needs to be an attorney-client privilege executive session, so you can discuss with your attorney the legalities and the negotiation of the contract. You can't do that without your attorney. So you can't just say, I'm going into executive session for contract negotiations and have no attorney present. I see that more frequently than I'd like to. The other thing about this real estate exemption is pay very close attention to those words too. Acquisition of real estate. It's not for the sale of real estate. So this is intended to be, the city wants to buy a piece of property, but doesn't want to convey to the world what it is willing to pay. So you can have that discussion in executive session, because of course, as soon as you say in open session, we're willing to pay X for this piece of property, well, all of a sudden the price went up. Those are the most common executive session rationales. Sometimes, from time to time, you may use employer negotiations, trade secrets of private entities, individuals. This is a really narrow one. Every once in a while, if you were going to get into like a discussion with someone about relocating a major company to your city, and you were going to talk about, they're going to ask for incentives, and you're like, well, I need to know something about your financials. That would be the kind of thing you can keep in executive session, because that's specific to them. Matters related to security measures, where the cameras are in the building, what the operating system security provisions are. You don't have to talk about that stuff in open session for obvious reasons. Then there's a whole list of things that I have here as an example for you, but you're just very unlikely to ever use, and there's more of them even than that. To call an executive session, and I know Todd has the script for it. To properly call an executive session has to be by motion, second and carried, just like every other official action of the council. Statement has to describe the subject to be discussed during the executive session, but not so much that it divulges anything, that is inappropriate to be divulged outside of the executive session. The authorization that justifies the closing of the meeting. So frequently those are the same thing. I mean, if it's discussion of attorney-client privilege matters, that may qualify as both 1 and 2 for the requirement. And the time and place at which the open meeting will resume. That is intended to let everybody in the gallery here know when you will be back into your regular session, so that they don't miss any other actions that you might be taking if they want to. Now, conversation is going on in the executive session, it takes an extra 2, 3, maybe 5 minutes to sort of finish that up and get your thoughts out, that's okay. That's not any kind of a violation. It's actually more troublesome, you can't come back early. For exactly what I just said, you can't tell the public we're gonna be back in 20 minutes, so they go to the restroom and grab a drink of water. You come back in 15 and take some action, and they didn't know that you were gonna be back. So that's the purpose of that. Actions and authorities, we don't have to go through this in a lot of detail. But remember at the beginning, I talked about how the law sort of has these different statutes that apply to different cities. It's because cities are what we call creatures of statute. They're the legislature, when it passed, when the Constitution was created 150 years ago, passed these laws that allows cities to be incorporated. And in those chapters, it will say they're authorizing statutes. They say the city can do this, and the city can do this, and the city's authorized to do this. And so whenever we look at, can a city take some action, as a lawyer, I always go back to, okay, where in the statute does it say we're permitted to do that? Because the country has kind of been founded on limited government action, right? You have to have an authority. It's not that you have blanket authority to do anything. So what we have in Kansas that applies to the city is you can do anything that the legislature has told you you can. So a statute expressly authorizes you to do so. But you also have under the Constitution what's called home rule. So anything that the legislature hasn't said something about, you have the general authority to regulate within the boundaries of the city. It's important I bring that up because home rule, actually a lot of things that you do are probably within your home rule authority. It is in the Constitution. It generally says you have the right to determine your local affairs and government. It means that unless the statute says you can't do something, or the statute says you can and you want to go outside of that, you have the ability to regulate within the city. You have the authority under home rule to pass what's called charter ordinances. So, for example, in Chapter 15, there's a section that talks about, various things with regard to the way the council is formed. The city, many, many years ago, passed what's called a charter ordinance to make some adjustments to that. What it means is if the legislature has passed a statute that is not uniformly applicable, so if it only applies to third-class cities, or it only applies to first-class cities, or it only applies to cities with populations of less than 30,000 people, home rule means you can change that statute as it applies to you, even though the legislature has passed it the way that it is. To do that, you can pass a charter ordinance. Charter ordinance has sort of special procedures to go along with it, but it's really very powerful. Most cities, every city I've ever worked with has some charter ordinances in its past somewhere. The special rules that go along with the charter ordinance, if you want to vary something within the law that applies to you, is it has to be passed, it has to be done by ordinance, it has to be passed by 2/3 of the governing body, including the mayor. So when we count how many people have to pass a charter ordinance, and you're going to make me do math here now, we got 6, we'd have to have 4. We would count the mayor because we'd have 6, so then we'd have to have 4 people to pass a charter ordinance. If you pass a charter ordinance, then it has to get published twice in your official city newspaper, and there's 60 days after that second publication before that charter ordinance takes effect. And during that 60 days, I think it's 20%. If you get a protest petition from 20% of the electorate to that charter ordinance, then it doesn't take effect, but it goes to an election as next general election.
Can I ask you a question on that?
Absolutely.
The 20% of electorates on the protest petition, is it whatever the most recent election is? Is it presidential election? Because I know sometimes there's some different rules.
That's a really good question. It changes depending on which protest petition.
Oh.
I'm going to let you in a secret on the legislature. They're not always consistent.
Oh.
And so sometimes protest petitions this is a long way of telling you, I'd have to look up exactly on a charter ordinance, whether it is the registered voters or whether it's voters in the last presidential or general election,
Okay.
because sometimes it says one thing for a protest petition for like the zoning, and sometimes it says another thing for question petitions, and
Okay.
sometimes it says another one. So I'd have to look it up. And I'd be
Okay.
more than happy to. I just
Okay.
don't remember.
Yeah, I
off the
guess
top
my
of head.
question would be like, this is what comes up quite a bit, like when there's a zoning case.
Yeah.
And it's like, was there a valid protest petition? I don't think anybody really in Kechi even understands what that is, how they do it, or how many people would have to sign it.
So a zoning case, I know I just said zoning, but actually a zoning case is a little bit different because of course the protest petition in a zoning case is not of electors, it's of the property
It's the
owners
property owners.
within the
Yeah.
notification area.
Yeah.
Yeah.
So this is where I think
Yeah.
it would be great to have some information to kind of have a general understanding of things that would affect city business.
Right.
Like, whether it's an ordinance or it's zoning, like, so that there's actually information that you kind of understand, applying to a protest petition, because a protest petition can be used for different,
Yeah. And there are
Things that
different
are-
rules depending on the protest
Yeah.
petition. It is very confusing.
Yeah.
I completely,
Yeah.
and I have to look them up
yeah, okay.
every time because sometimes, like you said, sometimes it's registered voters or registered
Property.
electors. Sometimes it's the number of
Voters.
electors who voted in the last election.
Right.
Sometimes it's the property owner.
Right.
Yeah.
Yeah, it's confusing.
I wish they would be consistent about that too. I'll tell you what. One that drives me nuts is not in protest petitions, but sometimes in publication requirements, the law says it must be published in the official city newspaper. Seems pretty clear. Doesn't really make a difference for Kechi because your official city newspaper is a newspaper. But like ordinances have to be published in the official city newspaper before they take effect. But sometimes, like in the budget hearing statute, it just says it has to be published in a newspaper of general circulation. For your purposes, that's all the same. You treat it all the same. But there's been a movement in the past several years for cities to name their website as their official city newspaper.
I think Bel Air has done that now.
A lot of places
Yes.
have done it.
Yes.
Wichita's done it. A
Yes.
lot of places have done it. I didn't really like that
Yeah.
when it came up for a lot of reasons. But the Attorney General a few years ago blessed that. Well, if you do that, that's fine. But that means you really have to pay attention to this distinction. Because in my view, if your website is the official city newspaper, that is not a newspaper of general circulation. So now we all have to pay attention to which ones get published here, which ones get published here.
Okay.
And I will tell you, there are cities who did not publish their budget hearing in the right place, and the state has slapped them around. So
And we
that's
have
a
this
little bit of an aside, but it's a pet
Okay.
peeve of mine.
And we
Okay.
had this discussion actually a couple of years ago, whether we were going to do that, and we chose to.
And I'm not gonna tell you you can't, because it is clearly
Right.
legal, but
Yes.
it does cause, we
Right.
have to pay attention to a lot of things once you do it.
Yeah, we chose not to. We did have a conversation years ago. Do you remember that, Teresa? Yeah.
Okay. Now, I'm gonna try to speed up a little bit, but please stop me if you have a question, just because I wanna make sure we get through a lot of it.
I have a KORA question, so when we get there,
Oh, okay,
I have a
okay.
question, I just need clarification.
And we may go through that pretty quickly.
Yeah,
but-
figured.
But please. So, you're all council members and a mayor, how and when to vote. So for the most part, remember you basically have three kinds of actions that the city normally takes: ordinances, resolutions, and motions without a written document. Like, I move to approve this contract, you don't need a resolution for that. Ordinances have to be passed by a majority of the members elected of the council. So if you have a meeting where only 3 council members show up, so you have a quorum and you can have that meeting, you need to pass an ordinance, all three have to vote for it to pass. A resolution, on the other hand, is passed by a majority of the members present. So if you have that same meeting with a quorum of 3 council members, 2 people can pass a resolution, but they can't pass an ordinance. Same goes for any other kind of motion that is not an ordinance. It is your duty to vote. Doesn't happen here, but there are places where council members, for whatever political reason, say, I just don't really want to vote on that, unless you have a conflict, which we're going to talk about in a second, or you want to recuse yourself for a perceived conflict. It really is your duty to vote. It is your duty to attend city council meetings. Absences from time to time are fine. That's not an issue. But if there's a council member that just never comes, that can be a legal issue. What is an official conflict of interest? I've listed them out here. I get this question a lot. This is what the statute says about when you must recuse yourself from the matter. In short, it's really, if you have a financial interest, a direct financial interest, then you should recuse yourself from it. If you don't have a direct financial interest or monetary benefit, you don't have to. This is, again, back to your point, Madam Mayor, this is another one where I often advise council members, if you perceive that there might be the perception of a conflict, even if there's not a direct financial benefit, you may recuse yourself. You don't have to, but you may in that case. Things that are not conflicts, but I often get questions about. Raising, lowering taxes, that applies to everybody. That's not necessarily a conflict. If you are within the zone notification area of a zoning case, not a conflict that you have to recuse yourself from. If there is if the matter affects relatives that are not your immediate family, not your spouse. Again, that's another one where think about perception versus legality, but the legality is you don't need to recuse yourself. Same thing, if you're associated with a charity or church or something that's coming up, you don't have to. Open records. Open records policy is very much like open meetings policy. The foundational rule is that records of the municipality should be open to the public unless there's a reason to close them. Again, of course, there are over the years probably 8 pages instead of closed records. Records can be anything. They don't just have to be paper, especially in our electronic world. These are very common exceptions to Open Records Acts, records of private people, records of governing body, personal records of them. Just because you're on the governing body doesn't mean that your personal records are subject to the Open Records Act request. Certain employment records. Personnel records generally are closed with the exception of name, title, and salary. The city clerk is the Freedom of Information Officer. He is in charge of administering the open records for the city. We have a set of procedures. Written request needs to have the name and address. We have an online form, do we not? Yeah. We have an online form for requesting Open Records Act. Name and address, the information necessary to ID the records, and then a certification that you're not going to use it for improper purposes, which I will talk about what those are here in a little bit. There are several closed records, again, many pages of them. The most common ones are attorney-client privilege, discussions and communications are not open. Personnel records, with the exceptions I mentioned, are not open. Criminal investigation records have their own whole set of rules about when they're open and when they're not. If a record request is made, the city must, quote, act upon that within 3 business days. Now, that doesn't mean they have to provide them in 3 business days, because of course it may take a while to, a reasonable period of time in order to gather those, but they have to at least respond and say, either yes, we are looking through to find what's responsive and we will get that to you within such a period of time, or if it's a really clear, you know, there's nothing here responsive, or whatever is responsive is a closed record, you can respond with that as well. If you do deny a request, you do have to give them the specific reason, so you've got to point out which of those exceptions you are relying on to deny that request. The statute technically gives inspection rights rather than copies, but they can request copies, and if they request copies, you have to give them. And you can charge reasonable fees for that, and that even has been cut back by the state. It used to be reasonable, which everybody thought was 25 cents a copy and staff time, and now the state has come back and said, that's too much, copies only cost a cent or whatever it is, so your actual cost for photocopies and staff time at the lowest staff member you have. You can, especially if the request is somewhat voluminous, there is a way that you can require, you can estimate how much you think that's going to cost. You can require the requester pay it in advance and then true up at the end. So you can't really overcharge them, but you can charge an estimate and then true it up when it's all been figured out. I talked about the certification that requesters need to make sometimes, and that is, you cannot use public records in a traditional commercial sense. So we get these from time to time, where if they're asking for information solely for the purpose of creating a list of potential business contacts or to go solicit something in a private commercial, that they have to tell you they're not doing that. And if it appears that that's what they're looking for, and sometimes it's really obvious, you can deny it on that basis. There are some things that you do have to give out, though, and that's the list here. Okay, good, we're just in time. Questions. Things that are open records or can be open records that you might not have thought about. We've kind of been through electronic records and those kinds of things. The Supreme Court case that I want to talk about is the very last one there, that Lincoln versus Freed, very recent case. The city manager of a city out east had a Facebook page, personal Facebook page, owned it, had it since 2008. In the 20-teens, became the city manager of this city, and used that Facebook page to post both all of his personal family stuff and post city announcements from time to time. A citizen made a comment to one of the city posts, and the city manager didn't like it. So I think the quote was something like, "Yeah, I delete those when they're stupid," or something like that. Was his standard. The citizen sued, and it went to the Supreme Court. Ultimately, what you need to know, the bottom line of this case is that any council member or the mayor, or really any city employee that has authority over a matter, if they post us, particularly in social media, about city business, it's kind of the same test as the records and the meetings and things. If you post about city business, that has now done 2 things. It has turned, at a minimum, that post into an open record that is discoverable with an open records request. And it has subjected it to the First Amendment of the U.S. Constitution, which means that unless something is blatantly pornographic, frankly, I mean, it's got to be way out there. Unless it's something like that, you can't moderate those comments at all. You can't delete them or anything, because that could be a First Amendment violation. Now, what happens if on your personal account a citizen posts out of the blue, some city-related
Yep.
item on your personal account. There's no interpretation of that. My view of that would be, try to be really careful about segregating your personal and city communications, because if that were to happen, I think it could conceivably create First Amendment problems on your personal account. It could create those open records problems on your personal account, and you didn't say anything about it, but the citizen, of course, went out there and posted something. And so, my advice is to usually try to keep those things as segregated as possible, just because it is possible for those things to happen without your knowledge, without your control.
Did he not also unfriend the person? Wasn't that part of the case?
I
That was
think
the
that's
problem,
right. I think
is
that's
that
right.
he cut him off from his account,
Right.
and
yeah,
that was part of the violation, is that you
Mhm.
can't cut him off.
Right.
So, can I ask my KORA request?
Please.
My KORA
Please.
question really quick before we run out of time here. Live stream videos are open records.
Live stream videos of open meetings.
Yes, they
Yeah.
are open records.
I would agree with that.
Yes, according to Kansas state law, I looked it up. So the city of Kechi needs to have all archived live streamed videos somewhere stored and accessible to the public. Is that not correct?
So if they're stored anywhere, if they are stored anywhere, I don't know if they're.
But once
if
it
they're
was
stored.
once it was live streamed to social media, it becomes public record, and you have to store that because you have created an open record.
Okay, so there's, I just wanna get at your question.
Yeah.
I wanna understand. So if you live stream something and it is recorded in a recordable form, if it exists on YouTube or Facebook or wherever it's been live streamed.
Correct.
And it still exists, I agree that is an open record that needs to be available for an open records request. If it's a live stream that is a live stream and then disappears for whatever reason, then there's no record. So the Open Records Act requires that records be open to the public. It is not a record retention statute, if you get my distinction.
So like on our page, it's on Facebook, but Facebook won't keep them after 30 days.
That's
Right,
So
if
once
it
it's
goes
gone,
away
it's
after
gone.
30 days, if you don't have another storage of it somewhere on the system,
But I thought you were required to have it. That's why school boards are no longer doing it, because you have to store that public record once it's been created. That's my understanding, is that once you've created the record, you can't just,
You have to.
well, at a certain point in time, any records can be destroyed unless there's a legal obligation to keep it. If there's a specific legal obligation to keep live streams,
because school boards are now stopping because
I'm not
they
aware
were
of it,
told
but
they had to
that
retain
doesn't
it.
mean it doesn't exist. And so
Okay.
I'd be more than happy
But
to.
I would appreciate you
Take a look
getting
at
clarification.
that. I don't wanna say there's no obligation, because I don't.
Yeah, because school
I
boards have
haven't looked at
stopped
that
doing it
specifically.
because they were told they had to store the records.
I was under the impression that you had to store it for a year if it was a recording of the meeting.
Okay, if there's a specific rule about that, there very well
Okay.
could be, I need to find that.
Okay.
Yeah, but my, again, Open Records Act is not a record retention thing. If there's a separate record retention requirement that applies, that very well could be. So
Okay.
I would need to look into that.
Okay, yeah, because when I looked it up, it said that you had to have that record available. So, clarification,
Sure.
yeah, would appreciate that, so. Okay, we are pushing.
I made it through, that's it.
Okay.
That's all I got. We can move on unless you got questions.
I would entertain a motion to adjourn.
So moved.
adjourn?
Okay, they're over.
Second.
Okay. Motion by Council President Hedstrom, second by Councilmember Moreland, all in favor?
Aye.